Bill of lading is an important document commonly used in shipping and international trade. It is issued by the carrier, usually the shipowner or a charterer. We will address the functions of a bill of lading and the common issues arising from the perspective of a contractual carrier. A bill of lading has three functions. Firstly, it is a receipt of the goods shipped on board. Secondly, it is evidence of the contract of carriage. And thirdly, it is usually a document of title.
The first function seems quite self-explanatory. The bill of lading is a receipt prepared by the ship and is a record of the cargo provided by the shipper. Under Article 3, Rule 3 of the Hague-Bisbee Rules, the carrier or master must issue to the shipper a bill of lading accurately describing the quantity and apparent order and condition of the goods shipped. Parties often disagree with the proposed descriptions of cargo or the proposed amounts of cargo under a bill of lading. Why? Well, because the seller will want to ensure that the bill of lading record matches with what they say they have sold to show that they have honoured the terms of the sale contract. From an international trade perspective, the bill of lading is an important document used in documentary credit. A seller of cargo needs to send the banks a clean bill of lading in order to obtain payment. This can create a conflict of interest between the shipowner and the seller when it comes to the content. There is usually a great deal of commercial pressure on the shipowners to issue a clean bill of lading, even where there may be some pre-shipment concerns. It is also well known that some terminals, supported by the local law, will only allow shore figures to be inserted into the bills of lading. It is important then that owners have a reliable loss prevention system in place to monitor cargo operations and insist on reviewing the draft bills of lading prior to issuance.
The second function to note is that bills of lading are evidence of the contract of carriage. As with every contract, members are recommended to carefully check the terms of the bills, both the front and reverse sides. Terms to look out for include checking the usual protective clauses are in place, any law and jurisdiction provisions, and any terms which are referred to as incorporated but are not attached to the bill of lading form. For example, reference to any incorporated charter party. Sale contract terms, including reference to a letter of credit number, are not relevant in a bill of lading unless in the unusual case where the carrier is also a party to the sale contract. Owners have no obligation to agree to inserting these terms when they are in no position to verify the details. The third function, which is often overlooked by parties in the industry, is that a bill of lading serves as a document of title. This means that an original bill of lading, whether it is transferable or not, must be presented to the carrier by the consignee before the cargo can be released for delivery. Where the bills of lading are transferable, owners are recommended to carefully check the bill of lading presented for the relevant endorsements to verify if the party claiming to take delivery is entitled to do so. In practice, shipowners commonly accept discharge orders against the letter of indemnity, but the underlying law requiring the presentation of an original bill of lading remains unchanged. In the event owners have reason to doubt the authenticity of the person claiming delivery, they are entitled to a reasonable time to investigate the identity of the lawful holder of the bill of lading. For example, if there is an issue with a letter of credit, the lawful holder of the bills of lading may in fact be one of the banks. In such a case, owners may have a defence by showing that the relevant banks had received notice of delivery, but this approach is not without risks.
In conclusion, there can be a tension between balancing a shipowner's rights as contractual carrier against the interests of the commodity traders or shippers. The importance of an accurate bill of lading is critical to minimise the commercial risks for the carrier. If in doubt, members are recommended to contact their claims handler at the club for advice on appointing a local surveyor, clausing options, and managing any disputes at the loading port.